The TRIPS CBD relationship has been discussed in the new context of emerging biotechnology tools. If you look into the last 30-40 years, what has happened is certain new tools in biotechnology like the recombinant DNA technology has allowed commercial utilization of nature and existing biological diversity without prior informed consent and access and benefit sharing. It means without any law, companies or individuals could actually, because of by virtue of use of these tools, use biotechnology and make commercial products out of it and put them in the market. Now these commercial products ultimately get patented if they are found to be inventive, novel and industrially applicable. Now example of such products are transgenic plants like the GM crops, transgenic animals like the famous Harvard OncoMouse, genes which are usually patented in terms of its information content although controversial, and genetically modified organisms. Now the TRIPS mandate in relation to protection of biotechnology products and processes is clearly laid down in Article 27. We have discussed Article 27 in the context of the provisions on TRIPS and public health. We would also briefly discuss it again here to understand the perspective from a biotechnology product or process. Any invention here within the framework of Article 27 would require to have an inventive step, novelty and industrial application. And as we know, what is the term invention has not been defined within the confines of the TRIPS agreement, nor is the term inventive step, novelty and industrial application. But it does not mean that WTO members have a kind of free will or carte blanche freedom to determine any definition by virtue of defining these terms, so that certain important biotechnology products and processes might be excluded. And it is for that reason that Article 27.2 and 27.3 clearly laid down the exclusion. The first kind of exclusion that pertains to certain biotechnology products and processes may involve exclusions based on ordinary public or morality, and also those kind of inventions and the commercial exploitation of which would lead to serious prejudice to environment, human health and plant and animal life. Now it is important to note that under Article 27.2 you cannot reject inventions purely on the ground that the invention per se is harmful, but you have to take clue from the fact that the commercial exploitation of such invention would have certain consequences which are mentioned in Article 27.2. Clearly Article 27.2 does not lay down very important condition, but it definitely lays down the ground. You cannot reject it otherwise. The grounds that are mentioned in Article 27.2 must be carefully complied with by WTO member countries. Under Article 27.3 there are other important exclusions. Those that pertain to biotechnology are clearly mentioned in Article 27.3b. WTO members may exclude from patentability plants and animals. Now this was specifically negotiated during the TRIPS Uruguay round, wherein there was concerns that higher life forms, if allowed to be patented, are clearly unethical and it may have certain consequences. And this kind of exclusion was primarily because Europeans already had it in their laws. Essentially biological processes for the production of plants and animals are also sought to be excluded under Article 27.3b. Members shall however protect plant varieties through either patents or a sui generis system or a combination of both. Many countries protect plants through patents, many countries protect plants through sui generis system, like for example India protects through a sui generis system. But what do you mean by a combination of both is not clearly known. However, it says that plant variety protection must be effective. However, the model is not clear. What kind of a model would you require to provide effective sui generis or effective plant variety protection is not clear, primarily because there are primarily two international agreements. One is the UPA of 1978 and the UPA of 1991, which deals with criteria relating to protection and enforcement of plant varieties. However, countries like India have not been party to this. Neither the TRIPS agreement requires countries to implement the mandate contained in those agreements. So it is not quite clear as to how effective this protection must be, but generally countries have based the criteria for protection on the ground of that the plant variety should satisfy, on the ground of novelty, distinctiveness, uniformity and stability. This clearly pertain to specific requirements of plants, because plants have certain characteristics that you need to show that they are uniform and stable and distinct over a period of time. There is no exclusion from patentability under Article 27. It means WTO member countries are required to protect microorganisms and non-biological and microbiological processes. Now, how do you construe microorganisms and what distinct definition would you imply for a microorganism is also not clear from the TRIPS agreement. Whether gene patents would be covered within the term microorganism, whether certain parts of animals which do not constitute animal as such or animal per se, would they be constituted within microorganisms, and how do you define the term of across jurisdictions is not particularly clear from the TRIPS agreement. Review under Article 27.3b is another important feature of this article. Under this article, there is a mandate to review the article and the implementation of 27.3 provisions. Now, this was primarily expressed as an important negotiating obligation during the Uruguay round, because there were concerns that certain countries who did not want to implement provisions on higher life forms, they may have things to say about their experiences post the implementation of the TRIPS agreement. So, by virtue of Article 27.3b, two important issues were sought to be raised later. Issues pertain to patent protection and under Article 27.3b and how countries have implemented, and how countries have also implemented the sui generis protection for plant varieties. Now, WTO Secretariat has conducted some wonderful information gathering exercise, and there are documents that pertain to how WTO member countries have implemented these obligations. The issue of conflict between the TRIPS and the Convention on Biological Diversity also became important during the Doha round, and paragraph 19 of the Doha Declaration specifically says that TRIPS Council should look into the relationship between TRIPS agreement and the UN Convention on Biological Diversity, the protection of traditional knowledge and folklore, and that the work of the TRIPS Council on these topics must be guided necessarily by the TRIPS agreement Article 7, which primarily deals with the objectives of the TRIPS agreement, and Article 8 relating to principles, and must take into account developmental issues that concerns the WTO members. Now, how this mandate has been interpreted is also interesting. Now, different countries have sought to bring in certain issues relating to TRIPS CBD conflict within the framework of Article 27.3b. However, there is no general common understanding relating to the nature of conflict between TRIPS and CBD, nor there is any common understanding as to how to find solutions regarding the same. However, there is some understanding that pertains to how TRIPS and CBD can be interpreted in a mutually supportive way. For example, either by exclusion of life forms totally. The TRIPS agreement Article 27.3 specifically requires you to protect certain kind of life forms, vis-a-vis the CBD obligations relating to sustainable development of traditional knowledge and indigenous and the rights of indigenous people. Now, how to require disclosure of origin, because disclosure of origin as far as certain developing countries are concerned has been one of the important negotiating challenges for them, or one of the important negotiating references. In Article 29, there is a requirement of disclosure. Generally, disclosure as understood within the framework of the patent law is a kind of quid pro quo, wherein the patent holder is expected to disclose whatever knowledge he is trying to seek a patent for. Now, and thus this disclosure shall be in the best mode possible, and it should be in the best mode possible as on the date of filing of the patent application. However, the developing countries are trying to seek an amendment to Article 29 by specifically requiring that patent applicants must mention in their patent application the source of origin of the particular biological material. This is also called as the amendment to disclosure requirement. And by virtue of this, developing countries think that they can achieve certain reasonable degree of certainty as to whether these patent applicants have actually taken the information, the traditional knowledge associated with biodiversity by requiring prior informed consent and access and benefit sharing. Now, there is also thinking as to the nature of conflict between TRIPS and CBD might relate to the grant of erroneous patents, because patents are allowed on life forms. certain member countries believe that patent system might lead to grant of erroneous patents, and they frequently cite examples like the turmeric. This turmeric example is pertinent because America prior to 2011 had a requirement under its patent law wherein novelty in relation to public use would be only local. So basically, prior public use in relation to any biological product would be construed within the territorial boundaries of the United States. This was prior to 2011, and due to this, what happened was the properties of the turmeric, the antiseptic properties of the turmeric, were sought to be patented in one of the applications filed by 2 Indians in the United States, and USPTO granted them. Later, the government of India had to engage experts to get the patent revoked, and finally the patent was revoked. Now, this example is frequently cited to suggest that the patent system, when not effectively tailored to the requirements of prevention of misappropriation, may indeed and actually lead to misappropriation.